presentation from the David's attorneys. You call your next witness, please.
Yes, we call David Shostak.
All right, it's coming up.
Before you sit, can you raise your right hand? Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can go ahead and have a seat. Can you state and spell your name for the record? You have a seat.
David Shostak. DavidShostak.
Good afternoon, Mr. Shostak. Can you tell the jury what you do for a living?
I am an arborist and an urban forester.
Okay. And can you tell us what is an arborist?
An arborist is somebody who specializes in the care of trees, and the identification of trees and the care of an urban forest and things like that.
No, I'm sorry. I just have to direct witness.
Sure, Scott, unfortunately, the microphone doesn't move, which means you have to move. So if you could just, it actually bends all over the place. The base doesn't move. So if you move it more towards you, you're a soft-spoken arborist. You need to make sure you can hear your words about arborism.
Sure.
Thank you.
Can you tell us briefly your educational background?
Starting way back, I have an associate's degree in math and science from Nassau Community College in New York. I have a dual bachelor's of science from the College of Environmental Science and Forestry in Syracuse, New York, in forestry and ecology. I have a ecology. I have a master's from Auburn University in forestry, and I did some post-master's work working towards a PhD at the University of Missouri in Columbia.
And where do you currently work?
I technically have two jobs. One is I am the city arborist for the city of Alpharetta, and my other job is as a consulting arborist for a company that my wife and I own.
Okay, and what is that company called?
It's Cadis Incorporated.
Okay. Can you give us an idea of your job and responsibilities as city arborist for the city of Alpharetta?
Sure. At the city of Alpharetta, my main role is to enforce the tree protection ordinance. In doing that, I handle all of the tree removals from private property, as well as all of the plan review for all of the new developments that go on throughout the city. That involves reviewing tree surveys, reviewing arborist assessments, making sure that the trees that are supposed to be preserved are preserved, and making sure that the trees that are supposed to be planted are planted. In addition to that, it includes all of the landscaping that needs to be planted as well. Trees, shrubs, ground covers, turf grass, everything like that all gets reviewed by me.
Okay. And do you go out on site to review?
Yes, I do go out on site to review tree surveys as well as verify the tree assessments. Basically, what I need to do is look at the reports from a third-party arborist and verify if what they're saying meets the science and the code. So I do that, verify tree surveys, making sure that if a tree's on a survey, it's there, or if it's not on a survey, it's not there. The sizes are right, all of that kind of stuff. A lot of this revolves around tree condition as well.
Okay. And you mentioned you have, outside of your city job, you have a consulting practice. Is that correct?
Correct.
Okay. And can you tell us about your jobs and responsibilities at your consulting practice?
Yes. So that consulting firm is a registered engineering firm. I am the arborist and environmental scientist for that firm. Most of my responsibilities revolve around doing arborist assessments. For example, one of the things that I do, if somebody calls me and says, hey, I have a tree in my yard, do I need to remove it? Do I need to care for it? Is it in good condition? I will go out and do those assessments. I also do risk assessments for trees. So if somebody calls and says, I think there's a problem with this tree, I do a full assessment to determine the biological and structural health of that tree to make sure it is safe and there's no risk associated with that tree. One of the other things that I do is appraisals and valuations for trees and shrubs that may have been removed from somebody's property without permission, in order to put a value on that for whatever the reason may be, whether it's a insurance claim, legal matter, or anything like that. Those are just some of the quick things that I do.
Okay. And you talked about valuations for situations where there may be a clearing already and you have to go out and value it after the fact.
Correct. I've done a few of those where all of the vegetation had been removed all the way down to the stumps, and I have to go and provide a value of what was assumed to have been there.
Let me ask you this. Are you a licensed arborist?
Technically, there is no licensing for arborists. It's a certification. It's a third-party certification through the International Society of Arboriculture. And I am a certified arborist, yes.
Okay. And do you maintain that certification in good standing?
Yes, I do.
Okay. Are there some kind of like continuing education or classes you attend to stay up to date?
Yes, you need to get a minimum of, I believe it's 30 continuing education credits every 3 years.
Okay. I want to focus us back for a moment to what you were talking about, the component of your work that focuses on appraisal or valuations of trees and shrubbery. Are there certain standards and methodologies you utilize in doing that work?
Yes, there are.
Okay. And can you explain that process to us?
Yeah, so there are 2 guidebooks out right now. One is the 9th edition of the Guide to Plant Appraisers. One is the 10th edition. Most arborists that I know are still using the 9th edition because the 10th has come out and there's been a little bit of controversy about the techniques. So, but in addition, when this was done previously, the 10th wasn't really out yet. They were still doing revisions and things like that. So with the 9th edition, it is a guide. So it provides you with how to do the appraisals, what you're supposed to look at, how the formulas work and everything like that. I also use other publications that have been provided as guidance documents on the guidance document, on the guide, to come up with my formulas that I use from the guidebook and the different ratings that I use to put into the formulas to get the final results.
Okay. To kind of help the jury understand how this process might work, can you tell us, so with regard to a situation where you've been hired to go out and value trees and shrubs that have already been removed, walk us through how you would go about that process.
Do you mean remove down to the stump, or do you removing the stumps are still there?
Okay, well, you tell us, is there a difference in how you would value if the stumps were still there versus a complete removal?
Yeah, so let's start with if the stumps are still there. So if the stumps are still there, I would go out and I would measure the stumps and identify the stump species, genus and species. In doing that, I would also do a condition criteria on the stump. And then I would also look at surrounding vegetation to determine if the condition is good on those trees, because without having the actual tree there, you have to go off of the data you can find. So I would look at the stump, measure it, identify it, and then, like I said, look at the surrounding vegetation to make sure it was good, fair, poor, whatever the condition may be. In addition to that, you look at the location because the location matters. And then I take that data, collect all sorts of stuff, take a bunch of photos, bring it back to my office, sit on a computer, clean up the data, run it through a spreadsheet, and then that gives me the value of the vegetation that had been removed. Now, that's a tree. If it is a shrub, I do the same basic data collection, but I also have to make an assumption about how large the shrub was. Because when I do replacement values on shrubs, it's a replacement value. So if you have a shrub that is 3 feet by 3 feet, then you go to the nursery and you say, oh, a 3 foot by 3 foot shrub costs this much, and that's the value you use. Going back to the trees, and I may be jumping ahead a little bit, but going back to the trees, what you do is you take the value of a smaller tree and you extrapolate it to the size of the tree that was removed to get an overall value. Included in that, in the formula, you have 3 ratings, like I mentioned before. One is for condition, one is for location, and one is for species. So different species are valued at different amounts from 1 to 100%. Different locations are valued from 1 to 100%, and a condition rating is based on 1 to 100%. So those things also get put into the formula to determine the overall value of that tree. So I guess I'm jumping back and forth between trees and shrubs, but that's how you come up with the value of the tree versus the value of a shrub that typically can be replaced in kind. If the shrub is so large that you can't replace it in kind, you typically calculate a volume. So if it's like a 10-foot tall by 10-foot wide shrub, you figure out the volume that shrub takes up, and then you figure out how many smaller shrubs that you can buy fit into that volume, and then you come up with your value based on, so if it takes 10 shrubs to fit in that volume, that's how much it is, 10 times the value. So that's how you do that. Now, moving on.
And now you're talking about, so we were just talking about what happens if you have stumps on the ground.
Correct.
And now you're going to explain to us what we do if we don't have any stumps on the ground. Is that correct?
Correct.
Okay.
So if you don't have any vegetation and everything's been removed down below the stumps have been ground, dug up, whatever it may be, the standard protocol is to find an area that you have determined to be similar in nature, and collect your data there. There's 2 ways you can do that. One way is by sampling the data. If it's a really large area, talk with my hands. If it's a really large area, then you do samples, and then you use standard sampling techniques to blow it up to the area. In a lot of cases, the area is small enough that you could actually measure out an area adjacent to it that may be similar, the same size. And then you collect all the data in that similar area and you do your valuation based upon what you find in that area. Again, trees and shrubs and ground covers, anything that you're looking for.
And so we don't have to repeat ourselves. Is it fair to say the valuation process is the same?
Yes, the formulas that you use or the valuation that you use for shrubs is the same either way.
And is that standard in your industry for valuations of trees, shrubs, vegetation?
Yes, it is. It is a formula found again in the 9th edition, which is what I've been using.
How many tree vegetation valuation appraisals have you done?
I went back and kind of tried to determine it. The ones that I've actually recorded and have files on is about 20 or so.
Okay. And do those involve, I think you indicated earlier, but do those always involve litigation?
No, they do not.
Okay.
No. As far as litigation goes, I believe of those 20, I've only dealt with actual court cases where it's somebody v. somebody about 7 times. I believe that's the number.
Thank you, Mr. Shostak. Your Honor, I would move to tender Mr. Shostak as an expert arborist and in the area of tree and vegetation valuations and appraisals.
Ms. Medwick, do you have any objection to that, or do you want to examine Mr. Shostak on his credentials and qualifications before I rule on that request.
I think I would like to examine on a very small issue that is kind of vague at this moment.
Sure.
Good afternoon.
Good afternoon.
I'm sorry?
I said good afternoon. There's an echo in here.
Yes.
Wide open.
Sorry.
All right, I muted it. He said good afternoon.
I thought he asked me something and I was other voices, so, you know.
Say that.
Sorry about that.
That's all right.
You mentioned a couple of times a ninth edition, guide that you use to, and that's instructive of performing these appraisals. Did I catch that right?
Correct.
Okay. You also mentioned that you personally use some other publications to guide you in your appraisals. Is that what you said?
Yes.
Okay. What other publications do you use?
I don't have a list of them in front of me. However, they are listed in the back of the report I presented as references.
Do you need a copy of that report?
Sure, that'd be great.
Okay.
Thank you. Do you want me to read these off?
Yeah, tell me a little bit about these publications.
Okay, so before I read off the publications, I'm going to say a lot of these publications are designed for the layperson. So there are terms and there are other information in there for the layperson to understand. The reason why I use these publications is because they give you definitions for the different condition classes of how you determine the condition. They give you the species class ratings because there is no species class ratings that I could ever find for the state of Georgia anymore. They stopped publishing that years ago. I do not know the year they stopped publishing that. So I do use those publications for the condition rating definitions. I do use it for the species ratings, and I also use it for the definition of the location ratings. So that's the main reason why I use those publications. I can tell you they're publications from different universities. One of them is two of them are from Purdue University. One is from the University of Tennessee. Some are from the University of Kentucky. So I've tried to find those publications that have that data in it as close to the Atlanta or Georgia as possible.
Okay, and thank you, and thank you actually for talking about them generally, so we can kind of condense this. So if I'm understanding what you said about the publications that you used, is you're using publications from universities talking about species identifications in other states because you don't have them for Georgia, and you tried to get states that are as close as you could get?
No, they're not species identifications.
So
They're
what-
species ratings for the
Ratings.
formulas.
Okay.
It's the species rating has to do with the intrinsic value associated with a tree. So for example, an oak may be rated higher than a pine tree because people like them better. So that's what those ratings are. And that rating gets put into the formula to come up with a monetary value based upon that rating.
Who decides, who's the arbiter to say that people like oaks more than pine? Feel bad, I got some.
Yeah, I always say that I hold no biases against any tree. But the arbiter of that typically is a group of arborists and horticultural professionals put together in each state that puts these guides together. And like I said, the one in Georgia hasn't been published in a few years, and I don't know what that few years is. I just never have seen one. So I do go to Tennessee and I do go to some of the closer states. And
Going for the closest approximation you've got.
That's right. And I can tell you, again, this is off the, where we're going with this, but in Tennessee, because a yellow poplar is the state tree, it is given 100. And I know here in Georgia that a yellow poplar is not given 100, and I don't.
One.
So again,
Whatever Alabama's tree gets.
yeah.
So is that a standard in the industry that you might kind of pick and choose publications for species ratings to help you out in a different state?
You're not picking and choosing to help you out. You're trying to find the closest data that you can use for your valuations.
Is that an industry standard, though?
It is an industry standard that you can use information that's out there if you don't have it for your state.
Okay.
So meaning there's none for Georgia. There's no published data for Georgia right now.
So there's no arborist in the state of Georgia who could perform the type of appraisal you're talking about that would have that information available to them?
There's no official publication with that data in it for the state of Georgia. So if an arborist was able to find that data that was published by a professional organization that had that data, I would gladly use it, but I have not been able to find it.
Okay. And does that kind of cover your explanation of those other guides that you use?
Yes, that is why I use those guides.
Okay. Thank you so much. And I'm going to get that report back.
All right, so on the table is a request to have Mr. Shustak qualified as an expert in the field of being an arborist and some of the evaluations of plants. Do you object to that or not?
I do have an objection because I think there are some concerns about, I mean, we're talking about very specific Georgia property.
Sure.
And
Is your concern about the weight that jurors would give his opinion because he's already explained there weren't some resources he thought would be available? Because that's not the question. The question is he qualified as an expert? Your questions you were asking him had to do maybe some of his methodology, but not so much about the degree of his expertise or his ability to offer an opinion that a layperson such as myself wouldn't have about the value of a tree, which you're free to explore with him. Hey, you're really triangulating. This is what Tennessee arborists say a tree is worth, and so what do we do with that? And he may say, I don't know, we give you a margin of error.
I mean, he's given a description that he's done 20 of these and that it sounds like there's really no comparison with anything Georgia related. So it makes me wonder about how is this reviewed? How is this accepted? I mean, we've had very little information about
Okay.
that.
Got it. I feel like we've had enough. I will qualify you as an expert in those two fields for the purposes of these proceedings. Of course, Ms. Medwick will be able to follow up when she's asking me questions about the very concerns she's got.
Thank you.
Back to you, Ms. Stern.
Thank you, Judge. All right, Mr. Shustak, can I draw your attention then to 3377 Habersham Road?
Yes,
Are you familiar with that property?
yes, I am.
Okay, and how are you familiar with that property?
I was hired to do an appraisal and valuation of the cleared area from the easement.
Okay, and did you go on site and look at the area?
Yes, I did.
Okay, do you recall when you were on site? Have you been on site more than once?
Yes, I have.
Okay, do you recall the first time you were on site?
I do. I believe it was April 20th of 2021.
Okay.
Or April. It was in mid-April of 2021. I don't want to give an exact date.
Did you prepare a tree appraisal valuation related to your assessment of the clearing of easement 2 in association with the 3371 Habersham property?
Yes, I did.
Okay. hand you that document. Do you recognize that document?
Yes, I do.
Okay, and can you tell us what it is?
This is the report I prepared for that valuation and assessment.
Okay, and if you turn to page 2, you don't have to read it for us, but just take a look at the top. Does that refresh your memory of when you may have been out on site the first time?
Yes, April 17th,
2021?
2021.
Okay. Can you tell us how you went about performing your tree valuation and assessment for this area? And let me strike that for a second. Mr. Shasak, were you out, did you bring anybody out on site with you?
I did not bring anybody with me.
Okay.
I was with Mr. David. David, sorry.
Did he stay for the entirety of your assessment?
He did not.
Okay. Can you please walk us through how you performed your tree valuation and appraisal for easement area 2?
Yes. So when I started to do the data collection, basically what I did was I measured the cleared area from the easement to find out length and width. And then what I did was I looked around and I selected an area that I assumed was similar in nature to the cleared area. This was also selected in a manner that was as random as possible. I didn't really have the ability to do much of a random selection, but I did review aerial photographs and street view photos beforehand. So I had a good idea of what the cover looked like from above. So once I selected that area, I did pull out my 100-foot tape and I marked some corners and made sure it was the same size and approximate shape. And once I did that, then I started to systematically go through that area and collect tree species and diameters and condition. And then I did the same for the shrubs. And then I did the same for the ground cover species that were in that non-cleared area.
And Mr. Shostak, just to help us and the jury understand, earlier you talked about what you can do if there's stumps existing and what you do if there's not stumps existing. In this situation, did you evaluate easement 2 to determine whether there were any stumps existing upon which you could do your assessment in that manner?
Yes, I did. I walked around the easement area that was cleared. I probed in the soil. I moved the pine straw around, looking for stumps to see if there were any present or if there were any remnants of stumps that I could find.
Did you find any?
I did not.
Okay. Did you encounter other objects on easement 2?
Yes, I found there was one tree remaining in easement 2. It had a light on it. I believe I found some irrigation heads in the easement area. Also found wood chips and pine straw. Some of the vegetation, the ground cover vegetation, like the ivy, English ivy, I believe had already started to grow back around the periphery.
Based on those observations, how did you determine, I guess, to use, instead of the stump analysis, you went with this alternative analysis? You've got to evaluate it under a different scenario. Was that based on your observations that day?
Yes, that was based on my observations that day, that there was nothing there for me to observe and collect data on within the easement area.
Okay. Judge, I would like to pull up the cover of his report so that we can help the jury see where he's evaluating.
report in evidence?
No,
No.
and I would object to the report being in evidence, Your Honor.
Well, the report can go into evidence. It doesn't mean it goes back with the jury. And given that someone's talking about it, it may make sense to make it part of the record.
Okay.
That doesn't mean that the jurors will necessarily see its contents, but, given your concerns that you've raised during your voir dire of the witness, what number is this?
This is Defendant's Exhibit 20.
Okay, so I will admit defendant's exhibit 20 for the record. Now, if you would show Ms. Medwick the page that you want to publish, she may not have an issue with that page. That's not going back to the jury. And I will look at exhibit 20.
If it's just a picture, that's fine.
I could do a call out of just a picture.
Yeah, if it's just a picture, that's fine.
All right, why don't we present just the picture from the first page of the. You're ready to get back on the record. All right, we're back on the record in the case of the Andersons versus the Marines. And during the break, Mr. Edwards and Ms. Sturm and I discussed a concern Mr. Edwards had. It wasn't even a concern, I appreciate him flagging it. It was, so this doesn't blow up, during his cross-examination of Ms. Sturm about her legal fees. Mr. Edwards is going to ask about communications that he sent to Ms. Sturm about the possible, his term is de-escalation tensions over the Easement 2 area. I'm going to allow him to enter those emails into the record, reference them, and share them if he needs to with Ms. Sturm, ask her, did she get them? And then did she pass them on to her client? So Ms. Sturm, you're free to answer in all the ways you think are appropriate to his questions. And you are objecting, one, because you think it violates 408. And you also want an opportunity, which I'm giving you, to supplement the record, again, not for jurors, with any emails that would fully round out the nature of the content of the dialogue between Sturm and Edwards at this time. Is that a fair summary of what we talked about? And if not, feel free to add any other objections you want to my ruling that Mr. Edwards used.
I think that's a fairly fair assessment of it. I would just add for the record that we will object also to the extent that it seems to be a cherry-picked, one-sided characterization of a communication. It seeks to insert attorneys as fact witnesses into the case, and we think it is more prejudicial than probative.
Okay, thank you.
Your Honor, before the jury comes in, I want to make sure that we have clarification before more substantive questioning starts happening. When we were talking about the motion in limine, I know that you said testimony about the vegetation was coming in. Is it still that limited?
That was my understanding. I was sort of surprised, but always happy to meet a new witness. I didn't think we'd be hearing from Mr. Shostak based on how, say your last name again?
Shostak. that's-
Shostak. Based on
Correct.
our discussion about the motion in limine, I thought my ruling was have at it with the vegetation, but with the missing trees based on what I understood the record would become, and as I think it has become, we wouldn't be getting into a valuation of allegedly missing trees because there's no stumps, there's no, here's what it used to look like. Here's some nearby stuff, and so I think there ought to be a few more trees here. Has that changed at all, Ms. Sturm, or you're still, when it gets down to the brass tacks of Mr. Shostak's expert opinion and valuation, is going to be the value of the loss or decrease in value of the clear cutting that occurred in terms of bushes, shrubs, non-significant trees. That's not the terms of art, but you know what I'm talking about.
Bushes, shrubs, under 6 dBH.
Yeah, that's what you're going to be dwelling on.
Yes, I'm, without forecasting his whole testimony, I was just trying to, help the jury understand which methodology he chose and why,
Okay,
right? And then we'll move on.
that's all good, but you're not going to be saying, and what's the value of the trees that weren't there? Okay, does that allay your concern?
It does. And the reason that I wanted to bring that up was because it has been worded as the tree appraisal has been very forefront in the wording. And so I just wanted to make sure we were still on the same page.
We are. Do we have just the picture up on the screen now? I mean, all we have is Mr. Shostak on the screen, but,
It's sad when the happiest pleading you receive in the day is a suggestion of death. You're a person party.
That's terrible. All right, can we check on the jurors, please? I guess it's they're ready.
After all that, there it is.
Is that,
Yeah, that's it.
I got it for you.
All right, for the jury. To the president, county board.
Thank you, Deputy Gordon. All right, let's resume, please, with the direct examination of Mr. Shostak.
Thank you, Judge. Before we took a break there, Mr. Shostak, we were talking about your appraisal valuation of easement area 2 and the easement area that you assessed, and then the comparable or the area that you utilized to make your valuation. We now have up on the screen an image. Does this help you explain to the jury? Can you kind of walk them through how you went about determining your appraisal area?
Yes. So this is an image I provided on the report. Basically, it's the property location map as well as the easement to and the areas where the work was completed. So if you look at the blue polygon, that is the easement area. And these are approximations because they're what I put on there, not a surveyor.
And can I stop you just for a moment? Your blue polygon, does it sits within that red,
Yes.
what are my shapes these days?
Yes, the blue polygon goes all the way from the bottom up. It encompasses the full red area. A little portion of the green area comes across and goes down. So it is the largest of the 3 polygons. The red area is the area that was cleared. And then the green area is the similar area that was adjacent. That is where I collected my data. The red area is the one that was measured. And then the green area was measured and the corners flagged. So I knew where I was and was able to collect the data only inside that polygon.
Can you tell us about your findings and observations related to the valuation of easement area 2 as it pertains to the vegetation, shrubs, and any trees under 6 inches DBH? And
Yes.
you may want to explain to the jury what DBH is.
Sure. DBH is what's considered diameter at breast height. That is measured at diameter, yes. Breast height. So it's diameter at breast height, and that is a forestry and arboricultural term, and it's 4.5 feet above the ground line. So that is where we measure trees, whether you're looking at it for timber or whether you're looking at it for aesthetic or whatever the reason may be. It's how you classify trees when you're doing reports of various and different reasons. So in doing my valuation of the area, there were approximately 4 trees that were under 6 inches DBH. And that's under 6 inches, not including 6 inches. And then there were various shrubs and ground covers of varying sizes and heights and types. If you would like me to go through that list, I would do so, but I need to use the report that's in front of me, if that's okay.
If you need to refresh your memory on the types, if you could just give us generally the types of vegetation and shrubbery that you encountered.
Yeah, so there was, I believe there was either an English or an oak leaf holly. There was a bunch of those. I believe there were some azaleas. There was this one called the Fuzzy Pride of Rochester. There was English ivy. Let's see, what else did I remember coming across? Do not recall the types of trees that I came across that were under 6 inches. It was back in 2021 when I did this. I'll just stop there
Okay.
without
And-
having the report for assistance.
Sure. If you want to take a look at the report to refresh your memory,
Yeah.
in your report, did you do a table identifying the types of vegetation and shrubs you encountered?
I did. It's on page 5.
Anything of note that you want to draw our attention to, Mr. Shostak?
What do you mean by that? What would you be?
You weren't sure if you had a complete list?
Oh, no, I did not have a complete list.
Okay.
So, I mean, I'll just run through the list. Do you want me to include the quantities as well?
That's fine.
Okay. So there were 11 English hollies, there were 2 azaleas, 7 tea plants, which is a type of camellia, 1 fuzzy pride of Rochester, 1 Mall's quince, 1 heavenly bamboo, which is a nandina, that's what you might know it as, and then there was English ivy and vinca. So those were the shrubs.
Vinca?
Vinca, yes, vinca. And then as far as the trees go that were smaller than 6 inches, there were sweet gum, water oak, southern magnolia, 2 of those, and that is it. That was smaller than 6 inches.
Mr. Shostak, did you take photographs when you were on site for your assessment?
Yes, I did.
Okay. Let me have you take a look at Defendant's Exhibit 21.
Thank you.
Do you recognize the images and have you had a chance to flip through it? Let us know if you recognize the images in that it's
Yes, so far these do look like my photos.
okay. Are these photographs of this green appraisal area?
Actually, there are photos of both areas.
And when you say both areas, is that easement area two that's been cleared and the appraisal area?
Yes.
Thank you. We would move to admit defendants exhibit 21.
Any objections to defendants 21?
No, Your Honor.
All right, it's admitted.
Mr. Shostak, did you walk through the appraisal area?
Yes, I did.
You didn't have any problem walking through it?
No, I did not.
Mr. Shostak, turning back to your appraisal valuation, can you tell us the opinions you arrived at for the valuation of the vegetation, shrubbery, and any trees under 6 dBH?
Yeah, the total value of that was around $90,000.
$90,000?
Around $90,000, yes.
Does your report include, you had indicated earlier in your methodologies, how you go about valuing. Does your report include a table that identifies the valuations for the various shrubs, vegetation, and trees under 6 inches?
Yes, in the appendices section, there is a Excel spreadsheet that shows the valuation of the shrubs, and then there is another that shows trees on it. They're two separate tables or Excel spreadsheets.
Thank you. Mr. Shostak, did you return to the easement area 2 and David property prior to this trial?
Yes, I did.
Okay. And when did you return to the area?
It was about a week and a half, 2 weeks ago.
Did you have any encounter with Mr. Anderson while on site?
While I was on site, Mr. Anderson was over, I believe it was near his garage, and he was yelling, "See you in court, big boy." That is all I remember.
Thank you, Mr. Shostak. I have no further questions at this time.
Ms. Medwick, do you have questions for Mr. Shostak?
Yes, Your Honor. And y'all can leave that picture.
Okay. You want me to move it?
Good afternoon. I believe you testified earlier that you were first contacted. You said you weren't quite sure when you were first contacted by Ms. Sturm.
No, I didn't say that.
Oh, so when were you first contacted by her?
Oh, actually, you never asked that question. That was never asked when I was first contacted.
Oh, I'm sorry. I thought she asked you. So do you know when you were first contacted?
It was about a month before I did my site visit.
So in March of 2021?
Correct.
Okay. And do you remember what that email said?
I do not remember what that email said.
Okay.
I believe it was asking if I was able to do what an appraisal or evaluation and if I had any conflicts. I
Okay.
don't know the exact verbiage verbatim.
Do you, were you given any more information about this case when you were contacted?
Not that I remember.
Okay. Just kind of take a look at these. And let me know when you've finished reading them.
Okay, I'm finished.
Okay. Did that refresh your memory a little bit?
Yes,
Okay. And so did that show that she contacted you on March 18th, 2021?
yes,
Okay. And did that also show that she let you know that she was representing the Davids?
yes,
And I think she also very clearly stated in capital letters that she did not represent the Andersons. Is that right?
correct,
She told you that her office sent a cease and desist letter to the Andersons?
correct,
Okay. And she told you that their specific concern was a clearing of easement two, which was previously wooded and consistent with other wooded areas at the back of the David property. Isn't that what she said to you?
correct,
Okay. She sent you a survey of the David property.
correct,
Yes. And she referenced a marked up version of a survey in her email.
correct.
Okay. All right. So you gave a deposition about your evaluation. Do you remember that?
I do.
Okay. And I believe that was around January 20th of 2022?
I believe so.
Okay. And can you still see the picture on the screen?
Yes,
Okay. So if I'm looking at the picture on the screen, and that's from your report, it looks like the red box is the one that you marked with the cleared area that Ms. Sturm told you about. Is that right?
well, that was marked after I did my site visit.
Sure, but was that the area that was being referenced in the email?
Yes,
Okay, okay. And the green area, the green box, it's marked as your appraisal area, correct?
correct.
Okay, and isn't it right that you randomly choose an appraisal area?
It is as random as it can be when you have a limited area of space.
Okay. And how limited was your area space?
My area was limited to the two properties that were not cleared.
Okay. And what are the dimensions of the quote unquote cleared area that you were evaluating? Did you measure that?
I did measure that. I would have to look back in my report for those measurements.
Okay. Let's see.
So this just gives the square footage, which was about 1,800 square feet.
Okay, thank you so much. So that cleared area was 1,800 square feet?
Correct.
Okay. And you had never been there before you went to perform this evaluation, correct?
No, I have not.
Did you know anything about that property before you went out there?
The only thing I knew about that property was reviewing some aerial photographs and Google Street View photos.
And of course, Ms. Sturm's email.
Correct.
Okay. But you wouldn't know when the Andersons purchased their property, is that correct?
Correct.
You wouldn't know when the Davids purchased their property, is that correct?
Correct.
You wouldn't know if before the area was cleared, if it actually contained weeds, yard clippings, poison ivy, plastic bottles, rotted wood, trash.
I wouldn't know that, but I did not see any of that in the Street View photos that I looked at.
Okay, and I believe you also said it was dense in some views, right?
The vegetation near the street, yes, was dense.
Okay, so would it be fair to say maybe you couldn't see all the way through inside there?
That's possible.
Okay. And you would also have no knowledge if anybody at any point in time had made any efforts to landscape it in any way, correct?
No, I would not.
Okay. So, let's see. I believe you said, well, do you remember kind of describing how you chose what you were going to compare the cleared area to?
Yeah, I mentioned that I looked for an area that was adjacent to it that had what I would assume to be the same or similar vegetation in it.
Bear with me for just a second. I'm dropping things. Do you remember testifying in your deposition that you randomly picked a spot?
Yes, I do.
Okay. So I am going to ask you some questions about that table that you were talking about with Ms. Sturm with the ground vegetation. You remember that just a minute ago?
Which table? The table with the list or the table with the values?
The table with the values. And do you have that in front of you?
Yeah, I
Okay.
still have the report in front of
You
me,
still have
yes.
the report, okay. So starting with the English holly, is that native to Georgia?
No.
No? How big does that get?
I believe an English holly would eventually get to about 15 or 20 feet tall.
Okay. You said 15 to 20 feet?
Yeah,
Okay. And you estimated 11 were removed?
no, I did not estimate anything. I counted 11 on the appraisal area.
Okay.
That was not an estimate. It was an assumption of what was on the red area, but it was an actual count of what was in the green area.
Okay, so when on the quantity removed column,
Correct,
you're counting things that are actually present in the green area
correct,
and assuming that they're in the red area.
correct. And that's the standard practice that we discussed earlier, that you do when everything's gone.
Okay. So then going down to the next one, the azalea. Is that native to Georgia?
There are native azaleas to Georgia, but most of them are not.
Do you know if the one that you looked at in the green area was native to Georgia?
No, I didn't identify it down to horticultural variety.
Okay, so not sure.
Right.
Okay. And how big does that get?
The azaleas typically get to be about 6 feet tall by about 6 feet wide. Those are maximums.
Okay, and so you saw 2 azaleas in the green area and made the assumption that there would need to be 10 in the red area.
No,
That's not what you said you were doing?
I did not make the assumption that there would be 10 in the red area. The way that this works is the volume calculation that I explained earlier. So in order to replace the 2 azaleas that are 5 by 3 by 3, you calculate the volume of that, and then you say how many you need of the smaller new shrubs you purchase from a landscape supply place that fit in that area. So it's a volume calculation to get a total area of missing shrub. So in order to replace the 2 larger ones, you would need 10 smaller ones.
Aren't those 10 smaller ones going to grow?
they will grow, but what you're doing is calculating the value at present day. You're not calculating the value in the future. You're calculating the value at day one.
Okay. Moving on to the tea plant. Is that native to Georgia?
No, camellias are not native.
Okay, and how big does that get?
Camellias can get fairly large. They can, I believe they can get to about 10 to 15 feet tall.
Okay. And let's see. Going down to the Fuzzy Pride of Rochester.
Yes.
All right, is that native to Georgia?
It's a native to the United States. It's not native to Georgia.
Okay, so not native to Georgia.
Right.
Okay. And how big does that get?
That was at its mature height. It gets to be about 10 feet tall.
Okay. And so for that one, so the one that you saw in the green area was at its full height.
Correct.
Okay. And so in your column that said quantity needed to be replaced, you have 2,250.
Correct.
Is that a typo?
No, that is not a typo.
Okay. Can you explain that?
Yeah, so if you do the math and you take 10 by 15 by 15 and you get the volume, and then you take the volume of a replacement shrub, which is a 3-gallon, which is 1 by 1, and you do the math, that's how many of the 1 by 1 or 3-gallon shrubs you need to fill in the volume created by a 10 by 15 by 15 shrub.
But with that math, conceptually, what that says to me is that you'd be, if you think of these as slices of that geometry, you cover that bottom slice with the 1 by 1s, but now you're buying and stacking on top of the ones you just planted, more 1 by 1s, and stacking, but not planting others, eventually crushing the ones you planted, because I get it, you have a prism that you're filling with all the 1 by 1s, but layers 2, 3, 4, 5, 6, 7, however many it would take, they're not even in the ground. They're hovering, maybe it's hydroponics. But I mean, am I understanding the math? And if I am, how's that the right number?
So you are understanding the math. And again, so to use a comparison, if I will, let's go back to a tree. So when you buy a 4-inch caliper tree, and caliper is the measurement at 4 inches above the ground line, okay, and you're buying that tree and you're saying, this brand new tree costs this much money, but the tree that was removed is this big, 25 inches, you take that smaller tree and you extrapolate it to that larger size. So you can't do that same kind of an extrapolation with a shrub. So the standard practice is to calculate the volume that that shrub took up and use a comparable plant to come up with the extrapolated or expanded value. It's not necessarily that you're going to put them all back in the same place and stack them. It's that you're using that smaller shrub to come up with a comparable value to the shrub that was in the ground. Now, if I called the landscape supply company and I said, hey, I need a 10 by 15 by 15 shrub, and they had one, that's the number I would have used.
Right, and that would be $1 gazillion, because that's a ginormous shrub.
Correct.
Okay, so.
So if you look at the value price, the gajillion dollars matches up.
Okay, understood. And what you're describing, even though part of it seems a little counterintuitive, it's the standard practice.
Correct.
You didn't do this just in this case.
No, and I didn't come up with it.
Moving on to the, am I pronouncing this correctly, Mall's quince?
Yes, Mall's quince.
Okay. Is that native to Georgia?
No, it's not.
Okay. How big does that get?
I do not know how big that one gets.
All right. We don't know. But you have one and you need 125 more of them?
Correct. It's similar to the last one. You take the volume for 5 by 5 by 5 and you fill it up with 1 by 1s by 1s to get that number.
Okay. Nandina, is that native to Georgia?
I do not know, but I don't think so.
Okay. How big does that get?
The largest I've seen in those is about 4, 5 feet.
Okay. And so for one, you need 4.5.
Correct, at the size that the landscape supply company had.
All
Again,
right.
if they had larger ones, I would have, used that.
Okay. English ivy, is that native to Georgia?
No, it's not.
Okay. Do you know, is that ever considered to be invasive?
It is.
Okay. Vinca, did I say that right?
Yes.
Okay. Is that native to Georgia?
I don't believe that is.
Okay. All right. And going back to that little green area right there, you hadn't been out there before the day you did all this, right?
No, I had not.
So you would also not know if that area had been previously landscaped. Is that fair to say?
I wouldn't know if it had been previously landscaped, but based upon the vegetation that was in there, I would assume it was landscaped at some point.
Because none of those plants are native to Georgia, right?
Correct.
All right. Those are all of my questions. Thank you very much.
Sure.
Edward and Mr. Logan, do you have any questions for Mr. Shostak?
No, sir.
Okay, any redirect?
Mr. Shostak, did you rely on my representations regarding allegations of clearing or your own observations on site of easement area 2 as to clearing?
I relied on my own observations. I go into everything that I do without any preconceived notions. I've actually gone out to a site where somebody has told me something and told them that they may not be correct and have left.
Understood. Now, Mr. Shostak, your green appraisal area, it seems to overlap a little bit onto the easement area 2, is that correct?
It does.
Okay, in your observations, was the, strike that, let me ask you this. When you were out on site, whether the first time or the second time, did you have an opportunity to review some other areas outside of maybe your appraisal green area, or easement 2?
Yes, I did. The last time I was out on site, I did look a little bit in the area of the easement that's only in blue, just a little bit.
The vegetation we just walked through, was it consistent with your observations in the blue area of easement 2?
I didn't actually identify anything specifically, but visually it looked similar.
Thank you very much. No further questions.
Just a couple follow-ups.
2 it is.
I believe you identified just a couple, you said under 6 inches in diameter trees that were not included in your report, correct?
No, they're included in the report, but they're not included in the table of vegetation. They're included in the tree table.
That's right, you did mention that. I'm sorry, I forgot. And when you were saying you looked at some of the stuff in the blue area, that's not included in your report, is it?
It's not included in my report, except there may be, and again, may, because normally I do this, is I do a general observation of areas surrounding. So there may be a general observation in my report of that area. Do not remember if I did that this time.
Okay, so it would have been a general observation, but the specific one we have is that table that you and I went through. Is that right?
Yes.
Okay, thank you so much.
Any questions from the jurors for our arborists? Yes, sir. Hold up, Deputy Gordon, please. Sir. Also, we look at these, we need to head out over your own. Okay. Sir, a few more questions.
All right.
You can flip through your pictures that were, I think it was exhibit 21. Do you have any pictures of the green area? In other words, the appraisal area that you sample on the W property?
Yes, I do.
Okay, can we put that there in evidence, I guess, which, pages, the pages, I think, are they numbered for you there? Like 1, 2?
Yes.
Okay, which pages from defendant's 21 are photos of the green area?
So the first 3 photos, page 1 and page 2 are, and you can actually see in those photos,
Let's stop then. So let's
Okay.
get, that first page up,
yeah,
because now they're on the screen in front of you, so the jurors can react to what you're saying.
yeah. So if you look at the bottom photo on the left, about 3/4 of the way down,
If you tap the screen, I'm risking it, a little circle with a pencil in it should show up in the lower left-hand corner. Match the screen. Is there a circle with a pencil in it, lower left-hand corner? Move your drink.
so what I've circled there is the flagging tape that I used to denote one of the corners of the easement area when I was out there, so I knew where I was while I was walking around.
But if I'm you holding the camera, are my feet in the green area and I'm taking a picture of the easement, or am I in easement 2 taking a picture of the green area?
You're in the green area, taking a picture of the green area.
Okay, and the picture above, same thing, I'm in the green area taking a picture of the green area.
Correct.
All right, and as we could look at the picture, please, on page 2. There's a little back circle with the arrow pointing like you're going backwards in time. I think if you tap that, it makes your red ring go away.
I don't see that.
What is the erase thing? Is it in a circle that goes?
Oh, here it is on the, maybe I have to touch the screen again for it to show up.
Yeah, feel free to touch the screen. It's a touch screen. Mind me.
There you go.
All right.
Yeah, so in this,
What does this show?
so in the center of that, you can also see another flagging tape that shows another area within another designation of the boundary of that. So I believe to the right is the easement area in that photo.
But again, this picture is taken by you standing within the green
Correct.
box that you drew on the original picture we were.
Yeah, correct.
Okay.
And if you keep going, you can kind of scroll through some more of those photos.
Well, they're in evidence and the jurors will be able to look at that.
Yeah, okay.
Is there a reason why you wouldn't have, you go back to, the picture with the blue and the red on it, please? While she's pulling that up, is there a reason why you wouldn't have done a little bit of a survey, if you will, of the blue area? It's also adjacent to the red area.
Yeah, because when I was out there in the field, I did not know where the bottom property line was, and I did not want to trespass and go on the neighboring property without permission. So I stayed where I was confident or comfortable that I was not be trespassing.
You talked about an English holly, is that correct?
Correct.
In the green area, about how old would you say that was?
That's really a difficult question to answer. And the only reason for that is because tree growth is related to species, genetics, as well as site conditions.
Sure,
And
but I'm not saying 2.7 years old. Was it a 1-year-old? Was it an 80-year-old? Or even that's hard to guesstimate?
yeah, so I'm going to give a decent range, but I'm going to say it was probably between 15 and 30 years old.
The English hog.
Yes.
Okay, thank you. Last question from me. Does industry practice support the notion of a single comparison? In other words, you did green area to red area, as opposed to say in home appraisals, I'm actually gonna go out and find 3 comparables out there, so that we can kind of triangulate, one's a little more expensive, one's a little less. How is this different from that, and why?
The only reason why it allows a single appraisal like that is because if you walk around and you look at other areas, then, and you determine that those are similar in nature, then you can do a single area instead of multiple areas.
Make sure I follow that. If you determine that the adjacent area upon which you're gonna rely is sufficiently similar, industry practices, that's enough data.
Correct.
Okay, and that was your conclusion here.
That was my conclusion.
Got it. Ms. Stern, do you have any other questions for Mr. Shostak?
No further questions.
No.
No, Your Honor.
Thank you, sir, for your time.
Thank you.
You can leave anything.
Leave those there.
Up there, and so the Dr. Pepper goes with you.
It does. You're correct. It does go with me.
All right. Everything else stays. Thank you. Bye, Dr. Pepper. Next witness.
Defense call Jean-Noel David.
All right, Mr. Debbie. And if you could come up, Ms. Stern, and click, it's kind of chaotic up there.
Sure, I will take care of that.
Mr. Schneider can, but there's not a lot of.
You are please, yes.
Mr. Debbie, can you,
Do the one thing.
State- yeah.
They've done it before, but
I guess,
you can recall, state your name and spell your name for the record.
of course. My name is Jean-Noel David, Jean hyphen Noel David, spell as David as the last name.
can you introduce yourself to the jury?
Sure. So I was born and raised in West Africa, Senegal, in a little city called Kaolack, 100 miles southeast of Dakar. My parents are from Lebanon. They fled the civil war. And so grew up in West Africa in an Arabic country, Arabic family. And then after high school, moved to Paris, went to college, and studied math undergrad, mechanical engineer as a master. Then started working in France, and then eventually made my way to the US in 1998 at Emory, where I got my MBA, and I'm here now.
Thank
And-
you. And you are a US citizen?
Yes, I am.
And you said you came to Emory.
That's correct.
Okay, and so you've been in Atlanta for how long?
Since 1998.
Okay.
Is it 26 years?
And what do you do for a living?
I work for a manufacturing company. We make radiopharmaceutical, nuclear medicine. To be a bit more specific, it's the active ingredient, actually, that's linked to a linker and a protein, and actually put in the body, kills the cancer cells. And we work in the field of prostate and breast cancer now.
Thank you, Mr. Dabi.
I head operation.
I'm sorry.
I head operation. I'm vice president of operation.
Okay. Turning to your property at 3377 Habersham Road, how did you come to purchase or buy this property?
Sure. So my wife mentioned we lived into a very small home. It was our first home. It was our plan to be 5 years. Ended up being 17. And then we moved into a house on Garden Hills. And then the day she walked in, she didn't like it. I passed the details, and then we agreed to, say, if we find the right place for us, let's just do it. And then we started looking, and 10 months later, not even that, we ended up on Habersham. And we looked for a while, and that was the one she wanted because we looked at it multiple times.
Okay. And talk to me a little bit about did you do any due diligence prior to purchasing?
Yes, we absolutely looked at everything that first didn't work in the first house, and then second didn't work when we walked into the second house, but also all the surrounding. So yes, we did, bedroom, bathrooms, daughter, son, also play because we have, our boy is very active, our daughter too. So yes, we did.
And did you walk the 3377 Habersham Road property before purchase?
Yes, we did.
Okay. Did you were you aware when you were looking at the house that there were easements involved?
Very well aware, yes.
Okay. And before purchasing, did you walk easement 2?
Yes, we did. I did.
Okay. And tell me, did you walk the fullest extent of it from 3377 Habersham to West Andrews, or did you walk West Andrews to 3377 Habersham?
Both ways, multiple times.
Okay. And did you have any problem doing that at the time?
Oh, no, not at all.
Okay.
No.
And can you describe easement area 2? Was it wooded or was it cleared?
No, it was actually wooded. It was wooded.
Did you close on the home with attorneys at Campbell and Brannan?
Yes, we did.
Okay. During your closing, were you provided a copy of your easement agreement?
Yes, I was.
Okay. Did you have any questions about the easement agreement at the time of closing?
No, I did not. It was actually pretty straightforward reading. No question, just confirmation of what I was reading. So it was very clear for me.
Okay. Were you, at that time, were you aware that the attorneys at the firm, Campbell and Brandon, also had closed on the neighboring property?
Yes, we were made aware. That's correct.
Were you aware, strike that. Did you move into the property at 3377 after purchasing?
We did not.
What transpired?
So we closed on March 27, 2020, and moved in on April 30, 2020. So during the whole month of April, we were in and out. We were having renovation in the house, painting, kitchen, yes.
Now, during this time, what were you doing for work?
Actually, my work is outside the state of Georgia, so I travel a lot in the States and also internationally, sometimes all the way to Australia.
Okay.
So same, yeah.
Same
Yeah,
field?
yes. Yeah, visit clients, visit other plants, yes.
Okay. At the time you purchased this property, were you traveling internationally a lot?
I was, yes.
Okay. At the time that the renovations were occurring, were you traveling internationally a lot?
I was traveling, yes, quite a bit, yes.
Okay. Did you know Mr. Anderson when you purchased the property?
No, I did not.
Okay. And when did you first meet Mr. Anderson?
It was during that trash incident.
Okay.
That's when we first met. I believe, yeah, it was on April 27, yes.
Were you home
Yeah.
at the time or were you traveling?
No, actually, it was, I know exactly because when you travel a lot, you know your Fridays and your Mondays. Those are the days you get on the plane. So no, it was a Saturday and it was April 25th, 2020. And I remember that because when first it was a weekend, so I knew it was a weekend, I was not traveling. Second, my wife and I were just coming down to the house because we knew the new bin was being dropped for trash. And we were meeting our contractor at some point that night to talk about the next next stage of renovation. So it was during the end of the day, on a Saturday. It was a Saturday.
Now, we've heard prior testimony in this case already about your knocking on the door of the Anderson home. Can you tell us, did the Andersons invite you in?
No,
Okay. Can you tell us how you left that conversation?
I honestly didn't feel warm and fuzzy at all. I was really looking forward to an opportunity to introduce myself, kind of, have a conversation, maybe, try to say, well, drop trash, why not? I mean, kind of reset. But it did not go that well. I walked out and I was actually the one thing that even light the bulb for me was he mentioned something about the workers parking in front of his trash bin and not to be able to access the trash bin. And that's why he actually dumped it in, not him, I mean, the son-in-law, in our bin. And I walked away, and that's it. Very, very skeptical, because it was a Saturday and a day, no workers, not able to access the trash on a Saturday afternoon. For me, the things were not connecting.
Okay. Does the city pick up your trash on a Saturday?
Friday morning.
Friday morning. Okay. Did you have any conversations with Mrs. Anderson at that time?
No, I saw her in the back.
We heard some testimony about the clearing of easement 2.
Yes.
Okay. And when you purchased the property, easement 2 was wooded?
Yes, it was.
Were you home when easement 2 or this portion of easement 2 was cleared?
So we have bought the home, we were not home.
You were not home or the family was not home?
The family were not home.
Okay. Were you out of town?
It was the period between April 2nd and April 25 when the renovation was happening.
When the renovation on your home was
That's
happening?
correct, yes.
When did you, when did you discover the clearing?
So when we moved in on April 30, the view, we remember really well, the view from our bathroom. There's a big window and you can, see this great wooded area in the back and couldn't see the city, the street of West Andrews. And it just appeared that now it's all gone and you can't just see West Andrew. So it was just soon after we moved in on April 30.
Okay. What did you do when you learned that?
Well, my wife and I talked about it, and it was a very big disappointment because that was a big selling point for us, is this privacy and being able to have this wooded area in the back.
Did you contact anyone?
I have not.
Okay.
I did not.
At any point after the clearing occurred, did you contact anyone, your closing attorneys?
I did contact, actually, yes, Erica, just reiterating and reviewing the easement agreement, making sure I'm not misunderstanding, making sure I'm reading it right. English being my third language, I always question myself when I read something. So having the lens of a lawyer or someone else to validate was important for me, which they did.
Did you have concerns that maybe you weren't reading the easement agreement?
Yes, I did have concern. Like I said, I learned English 25 years ago, so it's I always question myself when I read something. Am I reading it right? So I always ask them, even sometimes my wife, and now my kids correct me. So that's a different. Or how do you understand this, and make sure I understand it. So yes, I do that.
Okay. Do you Does the name, are you familiar with the name Whitwood?
Yes,
Okay.
parcel, yes.
Who is Mr. Wood?
Part of the closing attorney firm.
Okay. Did you reach out to Mr. Wood?
I did.
Okay. Did you inquire about your easement agreement?
I asked the very, very specific question, please Whit, help me understand, am I reading this right or am I missing anything on the easement agreement?
Okay. And following your conversation with Mr. Wood, how did you feel about your understanding of the easement agreement?
Well, first, it made me feel good because I understood it and read it right. So that was a relief on my end. But it was not a good feeling because now suddenly I'm in contentious, well, sorry, in my mind, just like suddenly, my neighbor has made a decision to do something that I thought was not allowed to do.
And so you felt confident in your understanding of the
That's correct.
easement agreement afterward?
That's correct. Yes, I
Okay.
did.
Let's talk about another incident that we've heard some stuff about. Fencing of the property line. And tell me about what happened with this fencing.
So I was home that day, and it was in October 2020, and I didn't see it. My wife calls me and says they're building a fence, and I says a fence, and then I went out there and I says effectively they're building a fence. So I went out and I saw the workers out there, very nice, introduced myself. And then he didn't speak English. I can get by in Spanish. It's the fourth language I didn't mention, but I lived in Mexico a couple of years. So I just, nicely asked him, hey, what you doing? And then, when English is not your first language, you get by, figure out how to communicate, so which I did. And then I understood he was building a fence. I understood he was going all the way down to the easement.
Hearsay. It's hearsay from his fourth language to his third language. Apparently this worker was speaking Spanish. It's clearly hearsay. He's relating what the worker told him either in Spanish or English or whatever.
He's not relating what the worker told him, he's relating his understanding.
Which is
Well,
100%
his
based.
understanding of what someone said. So let's not get into what someone, we can talk about what he told the workers, and maybe as a result of that exchange, the workers stopped working or they handed him a business card, but not his sense of what the response was.
Mr. David, did you observe the area that the worker was working in?
Yes, I did.
Okay. Did you make personal observations about where the work was being done?
Yes, I did.
Okay. We've seen some, I believe, some photographs. Yeah, different exhibit. And let me hand you what we've identified as Defendant's Exhibit 10. Do you recognize this picture?
Yes, I do.
Okay. Can you tell us what it is?
Yes, it's a worker, someone building a fence. There's yeah, that's what it looks like. He's putting a fence up.
Okay, in this picture, there's a worker, and in the photograph, the back of the worker is what we see, is that correct?
Is that correct? The fence, yes.
Okay, what side of the fence is that showing? Is that your property?
That's a view from our side.
Okay. Your Honor, we would move to admit Defendant's Exhibit 10.
No objection.
It's admitted.
Cheers. And Mr. David, can you help the jury understand where this is the worker? Is the worker on your property or on the Anderson property?
No, he's on our property.
He's on your property. There's some wood pieces that are leaning and, oh, I am so sorry. Take two. Okay. In this photo, the worker is standing on your property or the Anderson property?
On our property,
Okay, and we see some wood leaning.
yes.
The bottom pieces of the wood, is that your property or the Anderson property?
No, definitely on our property.
Is this fence that's going in, is this on the property line essentially?
It's actually wood.
Objection, no foundation.
Mr. David, do you know the location of the fence that was
I-
installed?
I do,
She re-asked it, are you renewing your objection or?
I think that requires a surveyor, and we've had 3 years litigation. We haven't seen a surveyor support this position.
Okay, you're renewing your objection.
Yes, sir.
Okay.
No foundation.
All right, if you want to ask him why he thinks it where it is, then if someone wants to explore that in cross-examination, they can.
Why do you think you know the location of this fence?
because I've looked at my survey that was issued during closing by McClung, and I know where the property line is, and they explained to me when they came out where they put the fence. where the-
Objection.
Don't go into what they said to you.
No, I'm not.
You just said they explained to you.
Yeah.
So don't go into what they explained to you, either. I'm gonna call that's what they said.
And based on their explanation, I actually draw a conclusion that this is the easement, this is a property line.
Now, in this photo, are we closer to your home, or are we closer to the easement, or are we somewhere in the middle?
Now we're actually just in front of Mr. Anderson garage, so we're closer to our home.
Closer to your home, okay.
And did you say, that the gentleman whose back is to us, he is on the side of the fence that faces your property?
That's correct.
So what is this brick? There's white along the edge of the photo.
That's probably the shed.
Okay, that's your
Our shed.
shed. Okay. Is that the brick path we've seen pictures of? It looks like a dirt or paved area, just a couple feet behind the gentleman.
That you walk on?
Yeah,
Yes,
we've seen these aerial
Yes.
shots of a
That's right.
brick path, and you said, sometimes I take that, sometimes I go through my back.
that's correct.
Okay.
Now, did you observe work being done on the fence further down closer to the easement area?
Yes,
Okay. Did you have occasion to observe any work beyond where the fence ultimately stopped, extending into the easement area?
they have already made the holes for the poles on the easement area.
What do you mean?
Well, when you build a fence, I'm not a contractor, but I'm telling you what I read on the Home Depot book. When you build the fence, you actually put the holes, put the holes of the, where you put the put holes, and then that's where you will end up putting the base of every certain distance of those big poles, and then you put build the fence in the middle, in between. So they've already marked it out and already identified where to make the holes, and in some cases on the easement already made the holes.
Okay, so you observed when you went out there and work was being done on the fence, you observed holes in the ground going down a portion of the easement area.
That's correct.
Okay, and then what happened?
Then I asked him to please stop at the end of the property line and not go any further down until I talk to someone.
You said that to the worker?
The worker. Yes,
Okay.
ma'am. Yes.
And after you spoke with the worker, what did you do?
Well, after we communicated, he gave me the business card of his the company so I can talk to someone in English, so we can, communicate, because he was having a hard time to really understand why I was stopping him, but he understood that I needed him to stop right there. And then I just called the office.
Okay, did he stop?
Oh, he was still going and finishing, like he understood he needed to stop, yes, at the property.
So he didn't proceed with fencing off the easement area?
He did not.
Okay. Did you call the company?
I did.
Okay. Did you call anyone else?
Actually, I went to knock on the door of Mr. Anderson. And then,
You went and knocked on the door of your neighbor's house?
that's correct.
Okay. And did you speak to anybody?
Yes, Mrs. Anderson opened the door.
Okay.
And, yes, I asked to talk to Mr. Anderson because we wanted to talk about, the situation. I was not aware, I wanted to talk about what he was doing and that he couldn't just go on and do it by himself without talking to me because of the easement agreement. But he was not home, so she gave me his number,
Okay, his phone number?
his phone number, which I called
Okay.
and left a message.
You left a message for Mr. Anderson?
Yes.
Okay. Did he call you back?
Yes, he did.
Okay. Do you know how
Oh,
long it took to call back?
Oh, it was in the morning, within the hour, he called me back.
Okay. And did you have a conversation with Mr. Anderson?
We tried to talk, yes, I explained why, I asked, the worker to stop because he was very, very unpleasant in terms of the fact that I was asking his workers to stop working. He just start saying, no, I have the right, I pay taxes on these properties, I can do what I want. And I said, well, there's an easement agreement, how about we talk about it first? So that was it.
Okay. How did you leave that conversation?
I ended up I was not 100% sure that he was not going to continue, but I really 80% sure that he was not going to finish. So I didn't know what to expect. So I just sat, in the back of my house and waited to see if they're going to finish the work or not, which they did not all the way down.
Okay. You indicated that you knocked on the door and Mrs. Anderson answered. Did you have any discussion with Mrs. Anderson about their garage
Oh, yeah.
or work they were doing on their property?
Yeah, because they were doing also some work on their garage, and I asked her if she was planning on having, people live up there, and she says no, they were just finishing it. That's
Okay.
it.
Did you tell her she couldn't have people
No.
living there?
No.
Did you tell her she couldn't renovate the garage?
No, not my place.
Did you tell her she couldn't do work on her property?
No.
Let me ask you a question. During your time at 3377 Habersham, how would you describe the traffic along Habersham Road?
It's actually pretty heavy and in some cases dangerous. We had a car flipped on our, on our yard one day because they were going too fast and just flipped. So yeah, it's pretty heavy.
Okay, it flipped over and landed
Yes.
upside down?
Yes, upside down. on our yard, and I don't know if you're asking me to go into that story, but he did. Yes, police came over and.
Okay, we won't get into what may have happened with the gentleman. We've heard, and I don't want to belabor this, the jury has heard a lot already. We've heard about the trash incident, we've heard about the fencing, we've heard about the clearing. How many times would you say that you've had an interaction or a run-in with Mr. Anderson?
4.
Okay. And what are those occasions?
So the first time was the trash incident. The second time was when we talked on the phone, but the fence incident. The third time is when I was on the easement, putting, I believe the picture was up yesterday or the video, putting a net for my kid He just screamed at me, says, "Oh, this is gonna cost you a lot of money, buddy." That was the third, and the fourth time was 10 days ago when I was with Mr. Shostak on the easement. He just screamed at me, "See you in court next week, big boy."
Give me an idea of how those interactions made you feel.
I honestly, I don't feel good. I mean, I'm very conscious about where I come from. So, I mean, I have parents play a civil war. I made it on my own all the way, living 19 years in West Africa, you know, and my parents never finished high school. I'm all the way here. I'm a U.S. citizen, and sometimes I do not feel good about it. I mean, I worry. I worry. I don't know. I mean, I don't feel good at all. I really worry about my safety. I worry about my wife, my kids. I travel a lot. I don't know what's going to happen. I don't feel good.
So we talk about four incidents. Trash, and that is shortly after purchase, is that correct?
The trash was on April 25, that's correct. And then the fence.
And then the fence. Do you recall, did you contact an attorney right after this trash incident?
I sometimes right after the fence, no, I did not after the trash incidents, no. But yeah, no.
Okay. Do you know when you first reached out to anyone at Weissman?
I did. It was right after the fence event in October. And the reason really was to once again make sure I was not missing out on anything on the easement agreement. And then instead of having a closing attorney, I says, well, I better talk to another attorney and give another opinion. And that's when I reached out to the office, yes.
Okay. Did you decide to hire Weissman at that point in time?
No, because the conversation was, no, sorry.
Don't tell anybody what
sorry.
conversations you had with any attorneys over at Weissman.
Sorry.
But did you decide to hire the firm?
I did not.
Did you feel like you didn't need to proceed with legal representation?
I didn't feel like I needed to.
When did you decide to hire Weissman?
It was actually early, right at the beginning of the year, the next year, early January of that year, 2022. 2021.
2021?
Yeah,
2021.
it was just a few months after.
And why? Why did you decide to proceed with hiring an attorney at that point in time?
There was, so I was actually traveling a lot, and my wife has brought to my attention that she's been seeing a lot of activity on the easement, and she was worried that they were going to do something. And then just like the history, they would just do it without saying anything. So I did not, that's when I decided to just hire the lawyers. I mean, that's when I decided, is because between the traveling, not being here, I figured even if I knew how to read English and the agreement, having representation would be a peace of mind for me.
I want to go back. I was asking you about your conversation with your closing attorneys,
Yes.
Mr. Whitwood, and I believe, Jeff, is this the one you were getting for me?
Which one? Yes.
Okay. let me just show you what we've identified as Dependents Exhibit 7. Do you recognize this document, Mr. Dovey?
Yes,
Okay. And can you tell us the date and what it is?
it was May 27, 2020, and it was from Whitwood at Campbell and Brennan to myself.
Okay. And it CC's Erica Eaton. Who is Erica Eaton?
She's our realtor who's, help her buy this house.
Okay. And so this is you testified earlier about you reached out to the
That's correct.
closing
That-
attorneys.
That's correct.
Is this when you reached out to the closing attorneys about the easement agreement?
That's correct. Yes, I did.
Okay. And did they send you another copy of the easement agreement?
They did.
Okay. We would move to admit B7.
Objection, hearsay. Out of court
I saw
statement by
that.
Mr. Wood.
I saw that coming too. Tell me,
I think we can redact portions. It goes to one that he obtained another copy of the easement agreement, so state of mind. And we can redact the statements from Mr. Wood.
what were you planning? Were you planning on publishing anything right now?
No.
You want it in the record at a minimum, and then we can work through if it's something that goes back to the jury, and if it does, what should be redacted before it goes back. Is that all a fair statement?
That's a fair statement.
Okay. If we handle it that way, Mr. Edwards, do you still have an objection?
I need to see what is redacted. I mean,
Sure, we'd have to work through that. It may be that everything has to be redacted, in which case it's in the record for other purposes, but would be something that the jury can see.
He's established that he got another copy of the easement around.
Agreed. I will admit defendant 7 subject to those caveats.
Thank you, Your Honor. Mr. David, after you hired Weissman, you were aware that a letter was sent to the Andersons?
Yes.
Okay. There's been some discussion about surveillance cameras on the Anderson property.
Yes.
Okay. Are you aware of cameras on the Anderson property?
Yes.
Okay. Did you have any concern regarding those cameras?
Yes.
Okay. And tell me about that.
Well, they're not anymore, but they were pointing really high for what you would want the camera to be looking at, especially in front of your house. I mean, if you're doing security in front of your house, should be pointed down instead of pointing up. And they were there's a few of them that were pointing up higher than they should.
Okay.
I had concern.
And do you know, did the cameras, were they readjusted or moved at any point in time?
Yes, they were adjusted.
Do you believe that was after the letter that the firm sent?
I believe it was coincidence just after that, yes.
So we've talked a little bit about these incidents that you've had. You've seen, and your son was here earlier testifying, you've seen videos of your son that Mr. Anderson has taken. Can you tell us how that impacts you and your family?
It's really hard actually to maneuver and manage. There's always the stress of the work that you deal with, the pressure and, that you deal with. And you always want to feel like your family is in a good spot, which is not the case. Knowing that my son stresses about being out there, that's always in the back of his mind, that I have to travel on Sunday night, Monday morning. If I have to drive from Macon, it's different than if I have to fly back from Sydney. So it's very stressful. It's been putting a lot of pressure and a lot of strength on, the family, our relationship suffering financially. It's tremendous pressure and even my health is, that's it's taking it, yeah,
It's stressful.
yeah, very stressful.
How would you characterize, or how would you describe the impact these events with the Andersons have had on your ability to use easement 2?
It has prevented us, it's preventing us from going out there and do what we want to do. Play or even walk by. I actually think twice before when I come back from a run, or even I want to go out from a run, just because I do not want to have an encounter with Mr. Anderson, because I know for some reason, every time I'm out there, he just shows up. And I also want to avoid any opportunity to run into the gentleman.
Okay.
So it's now it's getting to the point where we don't want to be out there trying to do the easement too. So
Okay. Do you, have there been any incidents that have led you to believe that you should not be using the area?
every time we are out there, the fact that we have to replace equipment, the fact that we are constantly have to watch it, I'd rather not deal with it than just deal with it, like be out there and deal with, Mr. Anderson. So I sometimes choose many times not to be out there.
Okay.
And that's easement too, but there's also the fact that my daughter drives now and comes back home by herself and parks on easement 1 by herself. It has crossed my mind that what if one day happens to my daughter what happened to my wife, where someone shows up from the back wall and starts screaming at my daughter because she's on easement 1 and that would be Mr. Anderson. So it's becoming a problem, major problem from a personal health and family financially.
Do you believe that the Andersons are intentionally preventing you from or impacting the way you use the easement too?
There's actually speculation.
His belief about their intentions seems like not something he needs to share.
Okay. Mr. David, do you feel like you are being personally attacked?
Yes, I feel like I'm being bullied. I think that maybe he assumed I don't speak English, I'm not from here. He just can come in and roll over and I will just not fight it. And he just probably assumed I don't speak English very well, or I don't understand the language of the law. And that by just doing it, by those actions, I would just back down and not fight it, and he'll take it over. Just like putting a fence through the easement and preventing me from walking on the easement and preventing my kids to get on the easement. And yes, I do.
This is always tough, but if you knew now if you knew then what you know now, would you have bought this home?
Never. Regardless of how much my wife loved it.
This isn't, Well, let me ask you this. What do you want?
I want to be able to go to work knowing that my family is safe. I do never want to be getting that phone call that I got one day, ever, when I was at work, and never, when she couldn't talk for 10 seconds, that felt that when I thought one of the kids was dead because Mr. Anderson had attacked her verbally on that, that day and called her those words. I want to be able to live my life. I never filed this lawsuit. I exercised an easement agreement. I bought a property like everybody does and wants to do. I'm living the American dream. Apparently not anymore, but I'm living the American dream. I just want to keep doing it.
Does it feel like a dream?
No.
No further questions at this time.
Medwick? Actually, let me check. We've been going for a little bit. You guys need a break? We're gonna take a break in a little bit anyway, but keep going, okay? Medwick?
So it sounds like there was about a month in between when you bought the house, when you first moved in, right?
That's correct.
Okay.
Yes.
Did you ever, and I believe you actually indicated that the dumpster incident happened on April 25th of 2020, right?
Yes.
That was the day?
Mhm.
Okay. So in between March 27th, 2020, April 25th, 2020, did you ever go over to the Andersons' house and say, hey, we're really excited about these easements. Can we talk about, like, what did you and the other owners do? Or how can we work this out? I know they're on your property, but, let's talk about it.
I don't understand. Why would I do that? I did not.
You did not? Okay, all right. And I believe you have stated that you cleared a path on August 12th, 2021 in your yard?
I removed some ivies.
Removed some ivy, okay. And that was from your yard over towards where easement 2 is?
It was more from West Andrew going up easement 2.
Okay, so some of it was in easement 2?
Yes, it was all on easement 2.
Okay, and that was fine, right?
What's fine? I don't
Like
understand.
you didn't think that, you thought, that's fine for me to do, I can clear this path?
Yes, I can clear this path, yes.
Okay. Did you talk about it with Mr. and Mrs. Anderson?
About clearing the path?
Mhm.
No.
Okay. Did you take any photographs of any of those surveillance videos that you thought were pointed at your house?
I've seen photographs. I did not personally take photographs.
You did not take photographs. Okay. Did you ever call the police about it?
No.
No. Okay. You, for efficiency's sake. We're 10.
Yes.
Okay.
Yeah.
And you pointed to that worker that's working on the fence.
Yes.
In this photograph. And it's correct that you've never had a survey done on where the Andersons fence is, correct?
I did not hire a surveyor to survey where the fence was.
Okay.
Yes.
So if you truly believed that he was standing on your property, why didn't you say something to him? You didn't say something to him, did you?
No, it didn't bother me.
Okay, all
I
right.
mean, you're talking about, sorry, clarify the question.
Well, I mean, you said, you made a point today to say that he's standing on your property.
I answered the question. If he was standing on my property, I said yes.
Okay, and so did you ask him not to?
No, I did not.
Okay. Okay. Um, I believe those are all my questions.
Edwards?
I'm gonna have a few minutes, not a lot. I mean, I can try to go through real quick.
Really up to you. You say a few minutes, they're just gonna hold it to those words.
Okey dokey. Fine with me. I'm gonna follow up on, excuse me. Y'all took a lot of pictures of stuff that y'all saw the Andersons doing that annoyed y'all, didn't you?
I'm sorry, what was the question?
Y'all saw the Andersons doing things you didn't like. You took pictures of it, right? Like this picture of the fence.
I can't, which picture?
There's a 2 or 3 second lag. There you go.
Oh, yeah,
Picture of the fence. Y'all took a picture of this fence going up, right?
yes.
And I just want to make sure the jury understands the claims that you are and are not making in this case. You're not making you're not suing us for trespass for this worker being on your fence, on your property.
Yes, ma'am.
I think he's getting into a legal area. I guess we can see where this goes, but I'm concerned he's getting into a legal area and I don't want him to elicit communications.
Okay. He's not there yet, so, you can ask your question again, so we queue up your question.
To your knowledge, are y'all seeking damages from my clients because this worker is on your property?
No, not to my knowledge.
To your knowledge, are y'all seeking damages against my client because of the wood supporting the fence that appears to be on your property?
The wood on, you mean, can you point it on the screen, please? What you're talking about? I just want to make
Is
sure.
that the wood you're talking about, the support beam right there?
No,
What are you talking about?
I'm asking you, what's the question? I'm sorry. You have to be very specific.
When Ms. Sturm showed you this picture, you said, yeah, there's some wood on our property.
That's correct.
And I'm trying to find the wood that's on your property. Is it not this support beam
Yes.
here? Okay. To your knowledge, are you suing my clients to recover damages for that support beam?
No,
Is that support beam still there?
no,
Okay. Now, you walked, and I underlined this, you said, I walked easement 2 before we bought the property. Does that mean just you?
I've done with my wife, I've done it with the realtor, I've done it by myself.
That's my question, whether it was just you or anybody else. Now, did you take your camera and say, oh, look at these beautiful trees, look at this beautiful 10 by 15 by 10 bush? Did you do that?
I did not.
So you have no pictures of easement 2 in what you contend is its heavily wooded and heavy vegetated state, do you?
I do not.
Okay. And you bought the property on March 27th. That's when you closed. You moved in April 27th, right?
April 30.
April 30, okay. And it's my understanding from your testimony that the tree clearing occurred between April 2nd and when y'all moved in on April 27 or 30, is that right?
That's correct.
Okay.
Yes. Yes.
So you're not contending that the clearing occurred between when y'all closed on March 27th and April 2nd, are you?
No, it's between the closing and when we moved in.
Well, you said April 2nd, and that was a specific date, which is why I wrote it down and asked you about it.
Yeah, just because it was a weekend, yes.
Now, you complained to the workers and to Mr. Anderson about the fence supposedly or planned to cross the easement, correct?
No,
Who did you complain to about that?
Mr. Anderson.
Okay, you complained to Mr. Anderson because it looked like the fence was going to extend beyond or into easement 2, correct?
That's correct.
And as we sit here today, does the fence extend into easement 2?
No,
Okay, so y'all got that resolved, didn't you?
it's not there anymore.
Was
It's
it,
not there. There's no fence there, so it's resolved, I guess.
was it ever there and it had to be torn out?
No,
Okay, so that's an example of a potential problem. You talked to Mr. Anderson and y'all avoided a problem, right?
I responded to an action Mr. Anderson has started, and then he stopped.
And he stopped because you picked up the phone and called him and said, hey, don't do this, right?
Because I caught him.
I understand you caught him. That's not the point. The point is,
So you're not lecturing him what the point is, you're
you
asking the
picked,
question.
I'm asking the question. This was resolved because you picked up the phone and called him neighbor to neighbor, man to man, right?
Because I caught him. Yes, he stopped because I caught him. Have I not caught him, he'll be all the way down, which he admitted yesterday.
Okay. I think we've got the point.
He said what he said, and then you ask the next question.
I think the jury's got the point. Now, again, you testified on direct a few moments ago that it is your position that part of the fence actually is on your property, correct?
It's really close. It's like within inches, yes. Also, yeah.
Well, is it really close or is it on your property?
I can't confirm where it is, but it is really within inch. So it could be on the property at some point and not on other areas.
And during your discussion with Mr. Anderson about the fence, you complained about it going across the easement. Did you complain to him about it being a 6-foot tall wood plank fence?
No, I did not.
Okay, so that was not an issue that you raised with him or tried to resolve?
No, I didn't talk about that.
Did you express any concerns to Mr. Anderson that, and by the way, I think your fence might be on part of my property?
I did not.
Okay. And we've been in this litigation for 3 years now, right?
Yes,
And Ms. Sturm's going to testify about the attorney's fees. Y'all spent a lot of money, right?
yes, yes.
Have y'all spent a few hundred or a few $1,000s to have a surveyor go out there and actually get a professional opinion as to whether the fence encroaches on your property?
I'm sorry, what's the question?
I'll move on. These surveillance cameras. Again, going back to the pictures y'all take when things upset you, did anybody take a picture of a surveillance camera like that one up there in the corner saying, oh my gosh, this is pointed at our daughter's bedroom? Did y'all do that?
I did not.
Okay. And I just want to make sure the jury understands. To your understanding, are y'all suing the Andersons for invasion of privacy based on this alleged illegal surveillance?
No.
To your understanding, are y'all seeking money damages from the Andersons for having illegal surveillance cameras in violation of the laws that Ms. Sturm cited in her letter?
No.
Okay. And kind of follow up to the surveyor on the fence, you have not spent a few hundred or a few $1,000s to have a surveyor go out and look at easement 2 and confirm how much, if any, of the sod encroaches on easement 2, have you?
I'm sorry, what's the question?
The question is, in the 3 years we've been in this litigation, have you paid a few hundred or a few $1,000s to send a surveyor out to say, I'm registered licensed surveyor number blah, 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 and the sod encroaches 3.2 inches into the easement area. Have you done that?
No, I have not.
You've had a total of 4 interactions with Tracy Anderson prior to this week in court, correct?
I have, yes,
That was the trash incident on April 25th, right?
yes,
The phone regarding the fence, right?
yes,
The issue with the net in August of 2012, right?
yes,
And a week ago Sunday, when you and Mr. Shostak were out there checking out easement 2, right?
yes,
Other than that, you've had no interactions with Mr. Anderson in any way, shape, or form. Is that correct?
to my knowledge, that's correct, yes,
Okay. Now, there have been some interactions between him and your son, right?
yes,
And one of those, we heard from your wife yesterday and your son today, Mr. Anderson was carrying a gun, right?
yes,
And it was in the case.
yes.
And your son called you, right?
He called my wife, I was with her, yes,
So y'all were in the car.
yes.
And how far away from the house were you roughly, or in minutes?
Really within 10 minutes, not
Within-
even, yes.
Within 10 minutes of the house.
15 minutes, yes.
So he left the property, right? Well, that's what he testified. Did you tell him to get the heck out of there?
Yes, my son, yes,
And you said, we're on our way.
yes,
And on your way, you picked up your phone and called somebody, right? You called these lawyers over here.
yeah, probably my wife did, yeah.
Okay. Your wife called these lawyers. Nobody called 911.
Objection. He's assuming facts that aren't in evidence.
Well, he's asking the witness what he remembers, so, if you don't know who was calling, you
Yeah.
talk about what you did, if you know your wife called the lawyers, great, if you don't,
I mean,
he doesn't
I-
put words in your mouth.
I don't remember calling the lawyers.
Okay. Well, did either you or your wife call 911
No,
because of Mr. Anderson allegedly waving a gun at your son?
no, we didn't call 911.
Now, you hired the Weissman firm in January of 2021, correct?
Correct.
This is almost 2 months before this incident with the sod and the incident in the driveway with your wife, right? You'd say
Yeah,
yes.
about a month, yeah.
And you said we hired them because of all the activity.
Yes.
Tell me the activity that was going on in October, November, and December that justified you hiring the Weissman firm.
There's people walking in, people out there, the trucks coming in, stopping by. I mean, there was more activity than normal.
People coming by the Anderson's house, you had to hire
Yeah,
one.
yeah, because there's people out there on the easement standing and just talking. Yeah.
So,
Activity.
all right, so this is just a few weeks. The fence went up in early October, right? You need to say yes.
Yes,
And you got that successfully resolved, right?
yes,
You covered.
I'm moving on.
The fence and being resolved maybe 400 times?
And I'm leaving that, I'm putting it in context for the next incident. Now, there's additional activity in the easement you don't like a few weeks later, correct?
I noticed activities, yes.
But this time you didn't pick up the phone and call Mr. Anderson, did you?
I did not.
What was the activity that was going on in late 2020?
There's trucks, pickup trucks, people going, I mean, there's movement.
Did you take pictures of it?
I did not.
Thanks, sir. Nothing further.
Do you have any redirect? Think carefully before you answer.
Very brief. Mr. David,
Yes,
did Mr. Anderson ever reach out to you before clearing the easement?
never,
Did he ever reach out to you before putting up the fence?
never.
Thank you. No further questions.
Jurors, any questions for Mr. Dudley? Yes, great. Deputy Gordon?
Simple. Maybe I overlooked it.
Thank you.
Raise your right hand. Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God? Go right ahead. Have a seat. State and spell your name for the record.
My name is Casey Sturm, KaseySturm as in Mary.
Ms. Sturm, how long have you been practicing law?
20 some years now, almost 24 years.
Okay, and are you a member of the State Bar of Georgia?
I am.
And how long have you been admitted in Georgia?
Roughly the same amount of time.
Okay, and where did you go to law school?
I went to law school at Vermont Law School. I got a dual degree and my law degree and also a master's in environmental law.
And have you been practicing in Georgia since being admitted in the state?
Yes.
Okay, and what's the nature of the practice been?
And to clarify, I practice both in Georgia and in South Carolina. My practice covers a number of different real property areas. I practice environmental law. I practice zoning and land use law. I practice condemnation, real property law, these kind of disputes that we're talking about with this case, dealing with easements, handle a lot of property contamination issues as well. Maybe stormwater often happens to be a big one, but also toxic tort type situations as well.
Other than your practice for pay, so to speak, do you do any teaching or any other education?
Yes, I teach land use law at Emory University's law school.
And have you been lead counsel in this case?
I have.
And are you familiar with the lawyers that have been active in this matter?
I am.
Okay, and including myself?
Yes.
Have you prepared a fee statement including detailed recitation of the time incurred in the matters done on behalf of the client?
Yes.
Okay, let me hand you exhibit number 35.
And ask you if that is your statement.
Collective fee statement.
Yes, so this would be a billing record from the firm. It runs from 10/26/2020 to March 5th, 2024. So doesn't quite capture through trial prep and this week of trial.
Okay. And what would you estimate your hours incurred during the course of this trial?
My hours incurred are just under 500.
I mean, in addition to the statements there, and in terms of the trial time this week.
10,000.
Right.
You all know how long we're here.
Right.
When you go home, we still work.
Okay. Are you familiar with have you reviewed those statements to determine the rates that were charged by the lawyers involved in the case?
Yes.
And was that work done under your direction or your supervision?
Yes.
And who were the lawyers that were involved in this case?
So the lawyers involved are myself, I'm lead counsel on the case, Mr. Schneider, one of our attorneys at the firm, Mr. Feldman, Brandon Arnold, and EJ Inying.
Okay. And
Yes, INYANG.
and you've reviewed the hours that have been billed and for this matter, right?
Yes.
Okay, and they're reflected in that statement. Based upon your expertise and your experience practicing law in the state of Georgia, are you familiar with the rates that are charged by lawyers of similar expertise in matters of similar complexity?
Yes.
And based upon your review of that, are the fees charged by those lawyers and the time expended fair and reasonable for the handling of this matter?
Yes.
And were they necessarily incurred as a result of both the defense against the plaintiff's claim and the prosecution of the counterclaim?
Yes,
And the cumulative balance of those statements, do you have that number?
I do.
And what is that?
So the cumulative balance of the hours, along with the fees and expenses, is 262,685.
$262,685, correct?
That's correct.
How long has this litigation been going on?
It's been going on, well, the litigation itself has been going on for close to 3 years.
Yeah. And do you have a sum of the hours?
The total hours spent, 662.2.
Your Honor, we would tender exhibit number 35.
No objection.
35 is admitted.
Those are all that I have for this witness at this time.
All right, Mr. Edwards, questions for Ms. Sturm?
Yes, sir, I have a few. Now, Ms. Sturm, on the very top of this inquiry activity work build report, October 26, 2020 through 3/5/2024. That doesn't mean that y'all are actually retained. That's just the time frame y'all went back for this report, correct?
So in our business records, what's going to show up is 10/26/2020 is going to tell me that either Jean-Noel David or Stacy David reached out to the firm.
Okay.
If we look at the first page of this exhibit is a summary. The second page will start with time entries. If we look at the second page, the first time entry is January 4th of 2021. And so based on our billing records, what this tells me is that a client reached out, they talked to someone, appears they didn't decide to hire us. So at the close of 2020, any, entries that an attorney would have made, the firm's gonna write off saying, we didn't get hired.
And we all have to run conflicts checks, so that would have been done around that October 26 timeframe, right?
Yes.
Okay. And the activity actually started in January 4th, right?
So there are time entries, January 4th, January 20th, 2021. It appears that the activity really picks up February 22nd and February 24th in that time frame.
Okay. Yeah, because there's maybe an hour or so in the month of January, but then, as you say, things really pick up February 24th of 2021, right?
That's correct.
Okay. I'm not going to ask you what happened. I think everybody knows that. And then if you flip over to page 4 of 65, about a little less than halfway down, an entry on March 11th, 2021. You are identifying an appraisal expert and valuation expert for conversion of forested land on back easement, correct?
Tell me that date again.
March 11th, it's ID number 3068757. It's on page 4.
Yes.
Okay. So March 11th, you've reached out to an expert, and we now know that's David Shostak, right?
That may be David Shostak.
Okay. And if you look at the next page, page 5, 1, 2, 3, fourth entry down is March 19th of 2021. Brandon Arnold attends a TPO hearing, correct?
Yes.
And then if you look at the next page, page 6, on April 1st, the 1, 2, 3, 4th entry down, the big one, 0.3 hours. Receive, review email communication from Randy Edwards identifying himself as new counsel. So that's when you first heard that I'd be involved representing the Andersons, right?
I believe so.
Okey-doke. And you were here for my opening and you heard Mr. Anderson talking about some activity going on in mid-August. Do you recall that? The clearing of the path to West Andrews and Mr. David putting those nets up and things like that. Remember that?
Okay.
Is that a yes or a no? I mean, you remember that testimony from the last couple of days?
Yes.
Okey-doke. And around that time, you and I were exchanging a bunch of emails, were we not? If you look on page 16 of 65, August 9th, we've received, review latest email communications from Randy Edwards, about the middle of the page.
Okay.
And then a few entries down below that, you have a 7/10 of an hour call with Stacy David, right?
Yes.
And then the next entry, most of it's redacted, but there is something receive, review, email communications from Randy E. I assume that's me.
Yes, I see that.
Okay. And then we go over to the next page, page 17, August 11th, the second entry, receive, review, email communications from Randy Edwards. Do you recall what generally was going on here in this August 9, 10, 11, 12 timeframe?
Not necessarily.
Okay. Do you recall that I reached out to you to try to figure out a way to de-escalate the antagonism that seems to be going on between our clients?
I'm going to object to this line of questioning. It's calling for some communications or communications between counsel.
Okay, your objection is noted. We spent some time talking about this outside the presence of the jury. I'm gonna overrule it so long as Mr. Edwards' questions are consistent with the ruling I entered when the jury was outside the courtroom.
You got a big notebook in front of you. Could you flip that white notebook is plaintiff's exhibits? Can you flip over to plaintiff's exhibit 18, tab 18 in that?
Okay.
Do you recognize plaintiff's exhibit 18 as a 4-page email chain between you and I, and the last page is just the footers from, this is an email communication. But email communications between you and I, the first one is August 11th, 2020, from me to you at 11:50 a.m.
Yes.
And then you replied a couple hours later. And then you replied a couple hours later, and we exchanged a couple emails trying to set up a telephone conference to discuss the issues raised in my email, correct?
It appears that we are trying to get in touch.
And do you see on August 12th, the same page, about a third from the bottom, time entry 309-2805, email communication with clients. Do you see that?
What page are you on again, Randy?
Still on page 17.
Okay.
So, and in fact, the last 4 entries on this page are all either email or telephone communications with your clients on August 12th, 2021, correct?
Yes?
And if you flip over to the next exhibit, plaintiff's exhibit 19, you recognize that as an email I sent you subsequent to our communications earlier, our telephone conversation earlier that day.
I recognize this as an email you sent me. Yes.
Your Honor, we would offer plaintiff's exhibits 18 and plaintiff's exhibits 19.
All right, over objections that have already been stated and are not waived but preserved, they're admitted for the record.
Thank you. And does this refresh your recollection that I was reaching out to you in an attempt to de-escalate antagonisms between our clients around the time all these nets and ribbons and everything are going up?
It is an email from you characterizing a conversation. I wouldn't say that's an accurate representation.
Well, would you agree that I actually did use the phrase de-escalate the antagonism that seems to be going on, specifically the long chair and new, bigger, bolder?
So let's not get into the
Okay.
contents. That was
All right.
exactly what we talked about.
All righty.
All right.
I will move on. And you had, I'm not asking about the substance of your communications with your clients on this occasion, on this day, but you ended up billing a total of 5.3 hours to this file on August 12th, consisting of exchanging emails with me and talking with your clients and talking with Brandon and a lot of other stuff that's redacted, right?
And give me that line item number.
Well, starting with 309-2793 on the 12th on page 17, all the way down to 309-0315 on the next page, your time entries are 0.2, 0.3, 0.1, 1.3, 0.8, 0.1, 0.1, 0.1, 0.2, 0.3, and 1.8, correct?
Yes, it appears like we are communicating with a special master in this case, among some other things. So we're doing various different activities.
Well, and among some other things are the issues that I have raised in the emails, correct?
Again, Mr. Edwards, I think it's a mischaracterization of the communications that were had.
And Mr. David, again, I'm not asking for what any advice was. Mr. David said yesterday during my cross-examination that whatever advice you would have given him, he would have followed. Do you recall that testimony from your client?
I recall him saying them.
Do you agree with that he followed your advice?
No, let's not get into it. Whatever your advice was, whether you follow.
All right.
You know better than
You,
that.
you know I can't answer.
You don't have any redirect. None. Okay, any questions from the jurors about attorney's fees? All right, thank you, Ms. Stern. Ms. Medwick, I didn't mean to shortchange you. Did you have any questions about attorney's fees?
I did not.
Mr. Edwards covered them. All right. Ms. Stern, your next witness. Sir. Oops, yeah, I missed that. Why don't we do this? We have to take a quick break. And while we're doing that, why don't you guys figure out how to get on the screen just the unobjectionable part. So ladies and gentlemen, you will go back to the jury room. Giving you a little digestive break. We'll get you out here as soon as we can.
Randy, I can do it
And
myself.
we'll
Thank
resume.
you.
Don't talk about the case.
I'll rise.
No outside research about trees. We'll go off the record. I'm sorry, Mr. Williams. I got swept up in arborism and lost track of the time. I told Ms. Stern I monitored that. So thank you for flagging it. You let us know when you're ready. Please.
Judge, if it's okay, there's something I'd like to talk about off the record, and then when he comes back, we create the record.
That was mine.
You again, okay,
I know, my computer went out.
okay.
This circle back to the standstill. My efforts to negotiate a standstill back on August 11. It was, this firm has produced her related to that time frame, and on the cross-examination, she would admit that she received my emails forwarded. I assume she would admit because she's billing her client, forwarding them to her client and discussing them with the client. I don't know what the discussions are, but just to establish what we contend is bad faith and one-like transaction. They're trying to get a standstill agreement. Mr. DeVee is out there picking up these nets and hiring these friends to come in and do all this. I think the jury need to put two and two together and see what's going on.
I think the jury's been adding a lot of numbers so far, but it's nothing wrong with having them add more numbers. Let me make sure I follow. You want to be able to ask Ms. Sturm if she forwarded to her clients what you're calling your standstill emails.
And I want to offer those emails to the evidence, because they are clearly not settlement communications. This goes from the feud's bad faith in underlying transaction. As my first email says, hey, Casey, can we have a chance to talk and de-escalate tensions? These new bigger, older women's and everything aren't doing anybody any good. We set up a time to talk. We have a totally unproductive conversation. Next thing you know, he's out there putting up the debt. The paths are being cut. And I send an email and say, seriously, do you seriously think if the jury's going to believe this, the court and the jury's going to believe this is a close? So this is all that was manufactured. The jury needs to hear that to put it into context for bad faith and underlying transactions.
So needs is different from whether they should be able to hear it. How is it not settlement? I appreciate it's not resolving the whole thing. And I don't bump into 408 much because lawyers aren't ever trying to push their communications in front of a jury. I understand why you would want to share. I get that. But how is a communication you have with Ms. Sturm to say, these are my words, let's sort a piece of this out? How is that not part of let's work the case out overall?
Well, because Rule 408 precludes evidence of settlement negotiations when offered to prove the validity or the amount of the claim. It does not bar, doesn't bar a pure settlement negotiation to prove bad faith or intent. And that was, we cited cases to that effect in our motion for pretrial ruling on this.
Well, before you go further, Ms. Sturm, do you have an objection to this?
I do.
Okay.
These are cherry-picked email communications that Mr. Edwards, I mean, essentially what he's trying to do is insert the attorneys as witnesses into a case.
Well, it's different from that. And I don't know that it's cherry-picked so much as it's relevant to a time frame. He's already asked Mr. David about, or Ms. David, one of the other, or both, where they said, no, we never heard from our lawyers that you, Mrs. Edwards asking questions. Did you ever hear that we were trying to de-escalate and then you put this net up? And my recollection of the answer is no, never heard of any of that. This would be impeachment of that. So I don't know so much that the emails need to go in as you would, it would not be inappropriate for Mr. Edwards to ask you, isn't it true? You're billing for some emails you reviewed and you forwarded these emails on to your clients. Now, whether they read them or not, Mr. Davies testified, I didn't read them. So that doesn't, so he can't go too far with it because there is testimony that I don't remember them or I didn't read them or maybe they're stuck in the spam folder. And there are ways to defend against the claim that in fact, Mr. Davies got them. But it's not settlement per se. That's really not what he's getting at as it is, this is impeachment. So
Also, Judge, in our motion, we cited Nevitt versus CMB Realty, as it relates to some of the discussions.
I want to be able to read this myself, which you filed a bunch of motions in limine.
This
What
is
was
the
this one?
motion for a pre-trial rule on disability of our efforts to maintain the status quo pending final resolution.
Got it, I'm looking at it. That's the one where we attached some of these pictures.
I
Okay,
attached some of the pictures and the emails, and the case says evidence offered for another purpose, such as showing bad faith may be admissible. And that's what this is for, is to show bad faith in the underlying transaction. Because she forwarded the emails to her, and in her bills, there's telephone conversations, she billed 5.3 hours on August 12th.
But the problem with this is, Mr. Edwards and I have a conversation. He, in an email, reports a one-sided version of that conversation
Right.
that I have to forward to my clients,
Right.
because I have ethical obligations
right.
to send that information. And so it's a complete misrepresentation of what's even transpiring. And so if we're gonna get into this, I mean, we almost have to get into all of the emails that kind of go around what's happening here.
We're perfectly fine with that, Judge.
And that is not what this case is about.
You being perfectly fine doesn't mean that.
No, because we were trying to negotiate a truce, and we were.
And that's your perspective on this.
Well,
Your perspective is you were trying to negotiate a truce. I'm hearing Ms. Sturm say, maybe it was a truce at gunpoint, it was a truce that we're gonna sue you, or who knows?
We're
And
already-
what you're negotiating is you're already in a 408. I mean,
You just said
might as
it.
well say we're in the middle of 408. Now, there is case law that is here's to say, and I'll read Nevitt, I don't need to rule on this right now. It's dealing with 408, evidence offered for another purpose, such as showing bad faith may be admissible, but 106 then gets in the way, which would be, again, your emails, but what about Ms. Sturm's emails and the full context of you saying, hey, we're willing to stop carrying guns around or whatever that everyone's concerned about. We're not gonna litigate in front of these jurors who really don't want to hear more about this case. They really don't. To now get into how badly did the lawyers behave with each other before the trial, because they're sitting it during the trial. And I mean,
It's for the narrow purpose of showing bad faith in putting up these nets, putting up these ribbons, having the pads cut in for the first time in over a year, is to show bad faith on that 2 or 3 day time frame.
so Ms. Sturm, tell me what your objection is to Mr. Edwards being able to ask you, did I present you with, I share with you some emails that were my efforts to, my view of what would de-escalate the rising tensions about the easement. At the time, these little pieces of tape were going, let me just finish. So did I send you some emails with my suggestions of how we could de-escalate this? Answer would be yes. And you can answer, I mean, it's not an only yes or no. You did. I don't think those were accurate representations of what was going on, and I didn't think they were helpful to de-escalate. I think they might have agitated my clients. Did you send them to your clients? Yes, I did. That's as far as he can go. It wouldn't be getting into that. He can characterize them the way he wants, and you're free to characterize them the way you want, and to say, and of course, there's much more to it than your emails. I didn't think they were accurate. Whatever your testimony is going to be, he opens that door by asking that question. That's why you often don't ask your legal adversary a question. You're like, I'll drive the bus through that one. But I think he's entitled to get into evidence that however the jury is going to weigh it, that you in fact did forward to your clients what Mr. Edwards is characterizing as efforts to de-escalate. Because Mr. David said, I didn't ever get anything like that. And then maybe he read it and said, this is the opposite of de-escalation. I'm even more insulted now. Okay. But right now the jury is left with Mr. Edwards saying, did you get these things? And Mr. David saying, no, I didn't. And it sounds like you at least forwarded them. I think he's entitled to explore that without diving into the substance of the communication.
Well, the one thing I'm concerned about, and again, it's his characterization that he's trying to de-escalate. And
Right.
so there's a problem with his characterization. And there's been a practice of this, you have a conversation and it comes back and
I'm only suing to de-escalate.
And so I think that's why when we have demand letters, those certainly come in, and that's typically where we start a bad faith conversation. These one-sided, let me have a conversation with somebody and then send you an email that re-characterizes it and then go, aha, you didn't do it. I have a problem with. The second thing is, it's a lot, so we've been around and around with this. There was an emergency motion before the special master on this. It makes a big assumption, one, what time did the email go? What time did the client read it, if at all?
It's more than just a 30-second reaction. If I'm remembering the testimony, tape goes up, net goes up the next day. So it's not a within 4 minutes kind of thing. And if you all think that jurors are following timeline that closely, again, you're misreading the jury. But I hear you on that, but you're able to argue what you want out of it. It seems like it is factually correct that you and Mr. Edwards had some conversations. He synthesized them in a way that may inure to the benefit of his client. That's his job. Send it to you saying, hey, maybe this is a way to de-escalate. And you, doing your job, send it to your client. You may even give them some advice that this is crazy, don't do this, or maybe it's a good idea. He can't get into that. He won't get into that. But he is entitled, I think, to say, did you get this? You can say, I don't characterize it the way you did. Did you forward it to your clients? Yes, I did. He can't go further than that.
Judge, just for the record, I'm sharing my screen. I mean, the words de-escalate, antagonism, the phrase, I specifically used that phrase in my letter.
I don't doubt what's in there. What I'm hearing from Ms. Sturm is that she's saying, not my words, not hers, a little rich to say, hey, it's the Davids who need to de-escalate and antagonism.
Well, Judge, if you read the whole thing, we asked for a mutual injunction to bar either side from accessing easement 2 until this case was over. It was, and I say on the next page, goose gander. Goose gander.
Right. Okay. So yours was in your mind a fair and balanced proposal. The jury's not going to decide that because.
I understand that, but just to put everything in context, this is what happened. If she wants to call me for cross-examination, by all means.
You know what? I don't know why you think that's going to advance your client's cause to dive down that rabbit hole right now. If that's where you guys decide going and the rules of evidence allow it, I'll do it.
Okay.
As painful as it may be for everyone involved.
Right. I think
We
I
are
think I've made my-
not witnesses in
No.
this case.
No, it was Mr. Edwards said you could call him, not that he called you. You're going to be on the stand talking about all the money that you're charging your client. And I think that is the opportunity for Mr. Edwards to say, hey, did you not get these emails that talked about a mutual de-escalation? The words are in there. And you're free to say yes, but it wasn't mutual or.
Well, I don't think those emails should come in.
No. I don't think they should come in either. My ruling is this. He can ask you about them. He can ask you, did you forward them to your clients? And your answers are whatever your answers are. And he can characterize what the gist of the emails were. But my ruling is, and he can object if it's not sufficiently broad, and I'll preserve that for the record, is that the emails don't see the light of day. If we want to enter them into the record, I'm fine with that. But they're not going to go up on a screen. They're not going to go back with the jury. But I don't think he showed me the whole thing, which is always smart. I don't think it is a mischaracterization on his part to say, I sent you an email that said, even if it may not have been, in your mind, a fair summation of the exchange you and Mr. Edwards had, and said, hey, you know what? Let's de-escalate mutual injunction. Just everyone stays off there. It goes back to the good old days of Nykerk's and Darby's, and people are just throwing their compost in there. And I don't mean their avocado rinds, but just the yard trimmings and everything. And it's a beautiful, natural, pastoral backdrop for both houses. And he's saying, let's just do that until we get clarity on how this case is going to go. You forward it to your client, and he then has that handhold that he's entitled to say, here's bad faith. I made this offer, and what is the response that my clients get? Across nets, a party of 8 people on Christmas Eve burning things where there's pine straw everywhere. If that's what argument he wants to make, he's entitled to make it. And I think this is relevant to that. And it isn't, if we keep it at this level, violative of 408. So that's my ruling. Mr. Edwards, if you want to tender those, feel free. just label them,
They're already marked. They're already,
plaintiffs X, whatever they are.
They're-
When we get Mr. Williams back in here,
Yes.
I'll admit them for the record. And that way you're preserving, if your argument later on, if there is an appeal, is that I unduly circumscribed your ability to explore this with Mr.
that's fine. And they're in our exhibit binders. I'll have her look at them. And I'll offer them, and I understand, of course, where you're going.
I think we would have to make an objection to, just simply because it's, again, it's a one-sided story. It has none of our communications. And so I think it would be improper to make him part of a record. If he wants to show them to me, I think that's fine. Making him part of a record without the complete record is a problem.
No, you make a great point. So I want to reemphasize, record, if there's an appeal, not for the jury to see, but if you think there are corresponding emails that ought to be entered to complete the record that an appellate body should be considering in connection with this pretty narrow issue, which is, can I effectively impeach Mr. David's testimony and establish possible bad faith? Those should go in too. I haven't heard Mr. Edwards say anything other than put them all in. So let's make the record as complete as you need it to be. That doesn't have to happen right now. The onus is on you to corral those emails and say, here's defendant's exhibit X. And these are the emails we think corresponds to the ones that Mr. Edwards admitted to the record during in about 2 minutes. Okay,
It's fine. Thank you, Judge.
all right. Mr. Williams, welcome back.
Thank you.
You're very welcome. You're always welcome to take care of things like that. Let me know when you're